Stop. Come here.
Stop.
Ahmed, come here.
Ahmed, stop. Stop.
So it's this one, this black one. Is that what this is? No. That looks like a Cruella de Vil or something, maybe?
That's Avatar.
Avatar.
They have a bunch of Avatar stuff. This is from Avatar as well. This Ace. That might be that's another box.
There's a bunch of Pandora bags. Yeah.
Because this guy's getting antsy. Yeah, we need to know what's going on because this guy's already ready to walk out of here. Cisco's got him? Yeah.
On the evening of July 21st, 2023, the Orange County Sheriff's Office responded to a burglary and auto theft call. The subject, aimed, was detained on Old Disney property near a vehicle whose ownership was immediately in question. This footage raises 4 distinct legal issues: the lawfulness of the Terry stop, the probable cause basis for arrest, Miranda compliance, and trespass authority.
Okay,
now we just have sir. Ahmed, stop.
Stop. Come here.
Stop.
Ahmed, come here.
Ahmed, stop. Stop.
Ahmed, come here.
Yeah.
You understand what I'm trying to tell you?
Yes, sir.
Well, let's have talk.
Okay, sir.
Okay? Very simple. When I tell you stop, it means stop.
Yes, sir.
Go right this way. This way.
Get your hands out of your pocket. Let's have a conversation.
Okay. Maybe we should have drove. Don't want to talk back.
I know, I just saw a parking door. Oh, it's like we're right next to the
More sunlight. Yeah, probably. So it's this one, this black one.
Yeah, it's a gray backpack. Yes, that's his backpack. Do they have any That could be a BMG.
Is that what this is? No. That looks like a Cruella de Vil or something, maybe?
That's Avatar.
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 Okay.
They have a bunch of Avatar stuff. This is from Avatar as well. This Ace.
Okay.
That might be that's another box.
There's a bunch of Pandora bags, yeah.
Because this guy's getting antsy.
Tell her just have the deputies come here.
Yeah, we need to know what's going on because this guy's already ready to walk out of here because we've been detaining him for a period of time, and he's up to breast of the law. He knows he cannot be detained X amount of time. He's about to walk out of here. We need to know what they're going to do because that's it. We could trespass him, do something with him, but I don't know. I don't know if you can get a hold of Christina or what's going on.
The first issue is the investigative detention. Under Terry v. Ohio, 392 United States 1, 1968, officers may briefly detain a person based on reasonable, articulable suspicion. However, the Supreme Court clarified in Illinois v. Caballes, 543 United States 405, 2005, that the duration of a Terry stop must be strictly limited. The detention ends the moment officers confirm or dispel the suspicion that justified the stop in the first place. It cannot be extended as a fishing expedition. On camera, a deputy explicitly acknowledges that the subject has been detained for an extended period, appears aware of his rights, and may be entitled to walk away. That acknowledgement is constitutionally significant. It places the detention squarely at or past the boundary the Supreme Court drew in Caballes. If probable cause had not fully crystallized at that moment, any arrest made immediately after would be constitutionally vulnerable. Under Beck v. Ohio, 379 United States 89, 1964.
Sierra 21, Big 820. I think Cisco's in the other room. Hallway.
It's open, beautiful.
Is it bad?
Is what bad?
What's going on with me?
Well, I'm arresting you for stealing a car.
Stealing a car?
Yes.
What the?
I mean, that's the charge. You know what you did. I'm not going to argue with you about it. I saw you do it.
The second issue is the probable cause basis for the arrest itself. The charge is grand theft of a motor vehicle under Florida Statute, Section 812.014, subsection 2, c. 6. That statute requires proof that the accused knowingly obtained or used another person's vehicle with intent to temporarily or permanently deprive the owner of their right to the property. Intent is the operative element. Circumstantial evidence, the vehicle, the merchandise found inside, and the circumstances of the encounter must together support a reasonable inference of intent. Grand theft auto is a third-degree felony under Florida law, carrying a maximum sentence of 5 years and a fine of $5,000. Under Florencian, Section 901.15, a warrantless felony arrest requires probable cause. Whether the totality of the circumstances here clears that threshold is the central question a defense attorney would challenge at a pretrial motion to suppress under the Fourth Amendment. The third and most significant procedural issue is Miranda. Under Miranda v. Arizona, 384 United States, 436, 1966, custodial interrogation requires prior advisement of the right to remain silent and the right to counsel. Once Amed was formally placed under arrest, he was in custody. Any questions posed after that point constitute custodial interrogation for Miranda purposes. No Miranda advisement is captured in this footage. Officers asked about birthplace, immigration history, gift card sources, and personal property, all post-arrest, all without advisement. Under the exclusionary rule established in Mapp v. Ohio, 367 United States 643, 1961, Statements obtained in violation of Miranda may be suppressed and cannot be used against the defendant at trial. Whether booking advisement occurred off camera is unknown, but the gap in this footage creates genuine suppression exposure for any prosecution relying on those post-arrest statements. The fourth issue is trespass. Under Florida Statute Section 810.09, trespass on property other than a structure or conveyance is established when a person remains on property after notice of exclusion. Deputies correctly warned aimed that returning to Old Disney property without law enforcement escort would constitute a separate trespass offense. That warning was legally accurate. Now the use of force. The physical arrest involved soft, empty hand control only. No strikes, no aggressive takedown, no pain compliance. Under Graham versus Connor, 490 United States 386, 1989, the reasonableness of force is judged from the perspective of a reasonable officer at the scene, not with hindsight. The subject was fully compliant. No resistance was offered at any point. The level of force applied was precisely proportionate. This is the correct application of the use of force continuum. The search incident to arrest was also lawful. Under Chimel versus California, 395 United States, 752, 1969, and United States versus Robinson, 414 United States 2, 18, 1973, officers may conduct a full search of the arrested person. The pat-down and shoe search captured in this footage falls squarely within that authority. No Fourth Amendment issue arises from the search itself.
Where were you born?
I was born in Morocco.
Really? How long you been here?
Since I was like 3 or 4.
Because I got to put on the paperwork.
Dude, that's a serious crime in Florida.
Most crimes are serious. You know?
I'm not gonna be doing it.
Okay, I'm just going to check you real quick. You have...
Phone, keys,
Can this thing go to the jail? It's like a vape. Is this a... What is this? Tell me.
my vape. Nope. No.
Okay, so...
You can put it in my bag.
Will do.
And then I have my wallet.
These are your car keys? They're going to go in your bag, too. No. He can take his car keys, right? This is your car, the Volkswagen?
Yes.
He can take them into the jail?
If it's his car key, yeah.
Yeah.
Yeah, they're not.
Well, it's going into a property thing. You know what's happening in my car?
Staying right here.
As far as I know, it's going to remain here. But being that you trespass from Old Disney property, before you come back to get it, you need to call Orange County. We'll do a standby. If you come in and try and collect your car without that, you can be arrested for trespass.
Oh, I didn't see this.
It's
You hang
my
on to them
wallet.
there? That's all your stuff in there?
Yeah.
You got an annual pass? What is that card? What's that thing?
That's my annual pass card.
So you had an annual pass to come here?
Yeah.
How much it cost?
Well, I'm doing a monthly plan. I pay like 90 something, 97 a month.
Mm-hmm.
Those are my headphones. I mean, it's pretty pricey.
That's why I asked you what it cost. And you got pass for Universal too? Wow.
From Florida.
What'd you say?
I said I'm from Florida.
Okay. Got another gift card. You had a bunch of gift cards in your bag. Where'd you get them from?
Just my gift cards.
BJ's. Who's Salmaine?
That's my brother.
Medical marijuana, huh?
Yeah, that's my medical card.
Alright, I'll stick this back in your pocket. Got anything in your shoes? Have a seat there.
Sure.
Put your foot, this foot, no, put this foot up.
Sorry,
This
what?
one right here.
This one?
Yeah. Stick your leg out. You can get it back in by stepping on it. How about your other foot? Anything in there?
Can I? Yeah, could you put your finger in there?
Well, let's look at the other shoe first.
Thank you.
Let's do that one.
Just a little bit.
Hang on. Stay still.
Thank
Good.
you.
All right, sit down. Watch your head. Those cuffs are behind you. Make sure they stay behind you.
Yes, sir.
When I put this in evidence, I could just put it in as miscellaneous items contained inside.
I'm sorry, I didn't need evidence. I mean, just make sure it gets checked in with him.
Well, they don't take the stuff.
They don't take it?
No.
I'll say you have to take his evidence.
Yeah. That's why I was going to dump it in his car.
So what are you supposed to do with it? What if he has a bag?
Put it in evidence. Safekeeping. They won't take it anymore. There's signs up down there.
That's just like chain of custody that we actually have the bag.
Yeah, that's fine. That's why I wanted to get rid of it, because the last time I went
10-3,
down.
They're checking on camera.
Hmm? Okay, good.
Like, you good?
Yeah.
Easy?
No, I'll call up Miller if I need help or anything.
Who?
Miller.
Kyle.
Kyle.
Oh. Sounds good.
All right, see you guys later. Thanks.
Thank you.
All righty. So you've never been arrested ever? Really? Well, you did something stupid today and you're getting arrested for it.
The lead deputy receives a B+. De-escalation was professional. Force was proportionate. The trespass advisement was legally sound. However, the on-camera deliberation about what to do with the detained subject reflects an investigation that reached its constitutional edge without a clear, decisive resolution of probable cause. The absence of any captured Miranda advisement before continued post-arrest questioning creates a procedural vulnerability that a defense attorney would exploit in a motion to suppress. Aimed receives a B. His physical compliance throughout the encounter was exemplary and materially prevented the situation from escalating. However, Aimed answered every question posed after his formal arrest without invoking his Fifth Amendment right to silence or requesting counsel under the Sixth Amendment. The correct response at the moment of arrest is clear. I invoke my right to remain silent. I want to speak with an attorney before answering any questions. Every statement made after that point, without that invocation, becomes potential evidence for the prosecution. Physical compliance protects your body, Silence protects your case. The Orange County Sheriff's Office receives a B. Multi-officer coordination was effective. Body camera footage was preserved. No excessive force was documented. The institutional weakness is the absence of a captured Miranda advisement and the on-camera deliberation that exposed the department to a credible Fourth Amendment challenge on detention duration. These are correctable process failures. A structured pre-arrest protocol establishing probable cause earlier and delivering Miranda at the moment of handcuffing would close both gaps. Before the grades, 3 lessons this encounter teaches. First, the Terry clock runs from the moment of the stop, not from when officers decide they are ready to act. Prolonged indecision during a detention is not legally neutral. Every additional minute without a clear, articulable basis adds constitutional exposure to any subsequent arrest. Second, Miranda is not a booking formality. It is a constitutional obligation that attaches at the moment of custody. Post-arrest conversation, however, casual is custodial interrogation under the law. Asking a person where they were born, how they acquired gift cards, or what is in their bag, after handcuffing them, without Miranda advisement, creates suppressible evidence. Third, for any person placed under arrest, the Fifth and Sixth Amendment rights are the only tools that cannot be taken away at the scene. Exercise them immediately. Every voluntary statement made post-arrest, without invoking silence, hands the prosecution its case from your own mouth. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to subscribe to our channel for more content on police court interactions.